Hello. For those of you who don't know me, my name is Ira Smith, President of Ira Smith Trustee and Receiver Inc. First, we hope that you and your family are safe, healthy, and secure during this coronavirus pandemic. We want to assure you that Ira Smith Trustee and Receiver Inc. is fully operational. Both myself and Brandon Smith are doing all consultations and meetings either by telephone or video conference. We would love to hear from you, so shoot us a message, give us a phone call. Today's Brandon's blog is a very interesting decision from the Court of Appeal for Ontario on the whole concept of undue influence. I know that it is important to every entrepreneur family, so I hope you can watch until the end of this video because I know you will get value from it. Undue influence refers to the situation where someone is pushed into doing something by someone else, normally involving their property, as opposed to making that decision and taking that action under their own free will. More often than not, we hear about undue influence in the whole area of wills and estates, where one or more beneficiaries takes advantage of a senior person to enter into a new will that favors that beneficiary over others. But it is also important to entrepreneurs and their companies looking to borrow funds from a bank, where the bank wants the spouse's guarantee and to have that guarantee backed up by collateral security. The reason for that is that entrepreneurs, by definition, are risk takers, so it is quite valid estate planning purposes to have the assets of the family in the name of the spouse who isn't the entrepreneur and perhaps not active in the business, to shield those family assets in case there are business problems. This Brandon's blog looks at a recently released decision of the Court of Appeal for Ontario. The name of the case is JGB Collateral versus Rochon, and the decision was released in July 17, 2020. Now, Mr. Rochon was CEO, chairman, and majority shareholder, or at least significant shareholder, of a Florida-based public company that borrowed money from a New York lender. The New York lender required the guarantee of Mrs. Rochon, and to have that guarantee backed up by collateral security, being a collateral mortgage on a farmland piece of real estate she owned in the province of Ontario. The company ran into business problems, defaulted on the loan, and sought bankruptcy protection in the United States Bankruptcy Court. The lender went to court in New York State because the terms of the loan and the guarantee were governed by New York State law, and they obtained judgment against Mrs. Rochon under her guarantee. They then came up to Ontario to get an Ontario order enforcing the collateral mortgage guarantee security, allowing the lender to seize the property in Ontario and to sell it. Mrs. Rochon defended that, and the lower court sided in her favor that there was the presumption of undue influence, and there was in fact undue influence in her providing that guarantee. The lender disagreed with the lower court's decision and appealed that decision to the Court of Appeal for Ontario. Motion judge had decided, and I quote, "This is a classic case of a spouse who unquestioningly complied with any and all requests by her husband to sign documents related to his business." The lower court judge found that 2 attorneys acted for the stakeholders. One of them was the company's general counsel, who was also the daughter of the Rochons. He also noted evidence of an officer of the lender, that officer had asked both attorneys and received confirmation that both Mr. and Mrs. Rochon received legal advice independent of the attorneys doing the loan transaction, and that they both understood the nature, the extent, and the ramifications of the guarantee. The lower court judge decided that this was insufficient and that the lender should have received a written certificate of independent legal advice for Mrs. Rochon. Therefore, the lower court judge found that since, in his view, undue influence was exerted on Mrs. Rochon, the guarantee was void and the mortgage unenforceable. This is notwithstanding the fact that the New York court found the guarantee to be valid and enforceable, and in the New York litigation, the Rochons never raised the issue of undue influence as a defense. The Court of Appeal for Ontario, it was a 3-judge panel, and they made various findings based on the evidence. The first, Mrs. Rochon never argued in New York State the area of undue influence for having given her guarantee. The motion court only considered the nature of the connection between Mr. and Mrs. Rochon. He fell short to think about the nature of the transaction between them. Third, while Mr. and Mrs. Rochon swore in their affidavits before the lower court that Mrs. Rochon had no financial interest in the Florida Public Company, they acknowledged in their factums before the appeal court that Mrs. Rochon had an interest in the corporation. However, they suggested that the interest was not significant, and for that reason, the judge's failure to clearly consider her interest was of no importance. The materials before the motion court, though, showed a schedule that was filed with the U.S. Securities and Exchange Commission, signed by Mr. Rochon, and it shows that Mrs. Rochon was a limited partner holding a 20% interest in a limited partnership that held a 35% interest in the Florida Public Company. The filing also said that she had the indirect right through the limited partnership to obtain dividends from the shares of the Florida Public Company, and she also had the right to any profit made on the sale of those shares in the Florida Public Company. So the Court of Appeal determined that Mrs. Rochon, in fact, had a significant interest in the company. The Court of Appeal also found that the company in many ways was really a family business. The Rochons' son and daughter each were employed by the company. Therefore, aside from her significant economic interest in the corporation, she had a desire to do whatever she could to make sure the company was sustained. As she confessed on cross-examination, signing documents when asked by Mr. Rochon, such as those with that New York financing, was both in her and Mr. Rochon's best interests. From a business perspective, there was a benefit to Mrs. Rochon for having signed the documents and given the guarantee. The Court of Appeal also found that even if there was a presumption of undue influence, and it did occur, the lender was put on notice to make certain that Mrs. Rochon was participating in the transaction of her own free will. The Court of Appeal said the lender recognized this, and the lower court judge improperly elevated the test of reasonable steps the lender had to go through to satisfy itself that Mrs. Rochon had independent legal advice to the level of a certificate, a written certificate, was not necessary. The Court of Appeal found that the lender's inquiries of the two attorneys, and both those attorneys who were involved in the financing, giving their assurances that Mr. and specifically Mrs. Rochon had received independent legal advice and understood the transaction and understood the ramifications of giving the personal guarantee was sufficient. So the Court of Appeal found that the lower court improperly boosted the onus on the lender to demand that the lender obtain a written certification from an independent attorney that he or she provided independent legal advice to the guarantor and that this was not necessary. Therefore, the Court of Appeal reversed the lower court decision, found the guarantee and therefore the collateral mortgage security enforceable, and that the lender could seize the Ontario property and go sell it. So this is a very important decision for entrepreneurs in Ontario and their companies. When the company goes to the bank to borrow funds and the entrepreneur is asked for his or her personal guarantee and the personal guarantee of the entrepreneur's spouse to be supported by collateral security, it is important to know the test for presumed undue influence and the evidence to prove or rebut undue influence. So I hope you have enjoyed this Brandon's blog, that you have gained some insight and found value from it. The Ira Smith team is fully operational. Both Brandon and myself are available at any time to answer your questions about this blog or anything else. Feel free to shoot us a message, give us a phone call. We are fully operational. We are doing all consultations by telephone or video conference. So we hope that you and your family remain safe, healthy, and secure.